Oftentimes, it is by law enforcement without a subpoena. In many contexts, it can be taken, and it can be taken in other contexts as well. There was a recent hearing this last summer looking at direct-to-consumer genetic testing companies, and the General Accounting Office did a sting where they contacted many of these companies, and they had on tape where one individual had contacted a company and asked if they could send in the DNA of their girlfriend as a surprise.
Oh, God.
And the company said, sure, send it on over, and we'll sequence it, and we'll send you back a report with all that information. This is a problem. We have no federal protections for it, and you know, you can only imagine the number of potential instances where someone might want to learn about another individual's health information.
So is there something going on at the state level? Sometimes it's even harder to get federal legislation. What about what's happening at the state level in terms of genetic protection?
Not a lot. We had a lot of activity that went on for the last 15 years related to GINA and the state laws around it. We now have about 45 state laws that address genetic privacy and discrimination in terms of health insurance and or employment.
What about
life insurance? We, of course, have a federal law. We have a number of state laws that deal with, sometimes not particularly well, but deal with surreptitious genetic testing that have been passed. But currently, there is not much legislation that is being contemplated at either the state or federal level. What we have to do is really build on the success that we had with GINA to include many of the other areas that GINA does not cover.
Jeremy, you know what I've noticed, and I know you know this even better than I do, but when I've testified in Congress, they want to hear, when they hear a horror story, that's when they're going to take some action. You know, when they see the abuse or they see something wrong, then they'll jump to it. Otherwise, it's like, oh, well, that could happen, but it hasn't happened. Is that your perspective, too?
They do need that. That's true, but sometimes even that is not enough. For example, a lot of attention recently has been placed on direct-to-consumer genetic testing companies. And for those listeners that don't know what these companies are, there's a number of companies out there now where you can send in your DNA sample and they will sequence it and send you back a report on essentially giving you a report about your predisposition to many types of diseases or conditions. It can give you ancestry information and such. And a number of questions had arisen over the analytical validity of some of this information, and which led to hearings over the summer. The FDA got involved and is now working on potential regulations. There was a hearing in Congress looking at these areas. And during the course of those hearings, privacy came up in a few times, but it was not seriously addressed, even though that's a serious concern. The clinical utility of a lot of this type of testing was a major point of discussion. Making sure these tests were actually accurate was a major discussion point. But at a hearing this past July in front of the FDA, where I was among 20 people who testified about direct-to-consumer genetic testing, I was the only person who talked about privacy. So I think privacy is, even with horror stories, is still, and genetics is still something that is difficult. It took us 15 years to pass GINA, even with dozens and dozens of stories of harm and privacy invasion.
Right. I think you need to have a face, or you need to have somebody like one of the senators or congresspeople or somebody experience that kind of privacy harm before anybody's going to really take notice. You know what I'm saying?
No, I think you're right.
I think that's what we've seen even when we were working on identity theft legislation. There's things that we had to do. We had to show Dianne Feinstein how we could get all of our information so easily. So, I mean, it has to really hit these people so they get it. And unfortunately, they don't get it. And we'll have to have some of these privacy abuses before anything happens. But is it only commercial companies that we should be concerned about?
No, I mean, I think that that the threats to genetic privacy can come from many different areas, whether it be commercial companies, whether it be banks or employers or actual companies that engage in the use of this information directly, pharmaceutical companies, but also I think from government, and not just in the forensic DNA capacity. But many of these databases that arise in the clinical setting, in the research setting, are housed by government or partially government-owned facilities, and the privacy protections are often insufficient. I think oftentimes in the rush to gather genetic information for use in research, insufficient attention is paid to making sure that consent is appropriate, that individuals who participate are given the appropriate amount of information, and that the actual safeguards in the use of the data are appropriate.
And like you were saying before, if the data is collected for one reason that you consent to, that it should not be used for other purposes.
Oh, no, absolutely. I mean, particularly with medical research databases and biobanks, it's almost impossible to predict how those samples will be used in the future in terms of research. At best, individuals are told what the initial use of that sample might be for, but down the line, they don't often know, and many people, wave their head and say, well, most of those samples are anonymized. That's not always true, but to the degree that it is, anonymization is by no means a perfect science. And health information, genetic information, is a particularly rich form of information. And taking anonymized information and re-identifying it is something that we're only really beginning to learn more and more about how to do and the actual limitations of what anonymization are. And as we learn more and more, we're finding out that anonymization is really not necessarily everything it's cracked up to be. And we're seeing instances where supposedly anonymous information is being re-identified. They were able to take, for example, not too long ago, former Governor William Weld's anonymous health records were re-identified by researchers who were working on this issue. So we cannot be completely secure that once information is anonymized, it can't be re-identified in the future.
And we don't have access to all the databases to find out where our DNA might be. If we do allow information, or we do allow our genetic information to be used for research, if we do consent to that, we have no idea how it's going to be used. There's no database for us to see how it's been used or who it's been shared with, do we?
No, I mean, in this country, you do not own your DNA once it's given away. You have no proprietary rights to it. So once your DNA is given away to use in clinical research or goes into a biobank of any kind, you really lose any type of right to learn more about it or access it or anything else related to learning about that sample. And And so, you have no way of really finding out how that might be used in the future. That's not to say that no one should ever participate in clinical research, and it doesn't mean that the wheels of science should stop moving. I hope that they move, and they move even more rapidly than they have.
Right.
But I want to make sure that the appropriate safeguards are in place, not just to protect people, but the truth is that I think, frankly, you're going to see more and more people be willing to participate in science if they feel secure that their information is only going to be used appropriately.
Right, and that is transparent to them. They'll feel safer. We're talking today with Jeremy Gruber, who is the president of the Council for Responsible Genetics. He's an attorney. He's been with the ACLU. He's been with many other organizations. He's testified in Congress, and he has been very involved in federal legislation to help get the Genetic Information Non-Discrimination Act passed by Congress. Worked very, very hard on that. He recently was involved in setting forth the newly released Consumer Genetic Privacy Manual, which you can find at consulforresponsiblegenetics.org/genetic privacy. And you're listening to KUCI 88.9 FM in Irvine and KUCI.org on the net. I'm Mari Frank. We also have a website, kuci.org/privacypiracy, and you can see Jeremy's picture, his bio, and we even link to his website. And he's spending a great deal of time helping us understand all this really very fascinating, yet also kind of insidious type stuff that's going on. Jeremy, I wanted to ask you, in terms of this law that you helped pass, can you give us a rundown of, like, a bullet point of what it really protects us, how it does protect us?
Sure. So the Genetic Information Non-Discrimination Act, or GINA, which is its acronym, covers two specific areas and has two separate titles for each. Title I of GINA deals with privacy and non-discrimination in the issuance of health insurance. And in that title, health insurance companies are not allowed to determine eligibility for coverage based on genetic information, charge higher or lower premiums based on genetic information, or consider genetic information as a pre-existing condition. In addition, they're not allowed to ask about genetic information as part of the application process, and once an individual or their family is covered by health insurance, insurers are not allowed to ask about or use that person's genetic information for any type of underwriting purposes. Title II of GINA, which deals with genetic discrimination in the employment context, makes it an unlawful employment practice for an employer to fail or refuse to hire or discharge or otherwise discriminate in any way against employee in terms of their employment. And it also prevents employers to access genetic information, whether by requesting, requiring, or purchasing it with respect to an employee or any family member of the employee as well.